the Director of Public Prosecutions, Ms. Cindy Clark, and the President of the Bermuda Bar Council and JLC member, Mr. George Jones. I extend once again our special thanks to the National Museum of Bermuda for bringing the Admiralty Mace, which was made for the Bermuda courts in 1697. I believe it's not on the brackets, or is it? Yes, it is. Well, thank you. You will remember that the Bermuda Judiciary annual reports for the year 2020 and 2021 were published without the special sitting of this court due to the COVID constraints. The last time there was a special sitting to commemorate the new legal year was in February 2020. Therefore, I'm very pleased to be present at the Bermuda, this special sitting in person, and more importantly, that you can also attend in person. So welcome and thank you for coming. With that short introduction, I call upon the Solicitor General to make his remarks.
President of the Bar and distinguished colleagues and invited guests. On this special sitting in the Supreme Court of Bermuda, commemorating the start of the 23 legal year, I rise on behalf of the Attorney General and the Minister of Legal Affairs and Constitutional Reform to offer a few words on the invaluable role the judiciary plays in our judicial system. As members of the judiciary, you are the guardians of the rule of law and the protectors of our constitutional rights and freedoms. Your tireless work is in dispensing justice and upholding the law serves as a source of inspiration to all. Your dedication to impartiality and fairness, even in the face of adversity, is a testament to your unwavering commitment to the ideals of justice. In a world where the need for justice is increasingly important, your role as impartial judges and magistrates is more critical than ever. The decisions you make impact the lives of individuals and shapes the future of our society. Your role in interpreting the law and ensuring that it is applied consistently and fairly is a cornerstone of a just and equitable society. Over the successive years, we have heard the pleas for more responsiveness to the judiciary requests. The ministry fully supports the judiciary and recognizes the vital role it plays in ensuring a fair and just society. To this end, the minister has supported the intended move of the Supreme Court, number 1, and the Court of Appeal to the Dame Lewis Brown Evans Bill, the replacement of the judiciary case management system for a modern system, as well as the judiciary's goal of enhancing its operational efficiency. The minister also recognizes the judiciary's needs for operational independence, although with administrative support from the executive branch of the government. On behalf of the minister, I would like to express our gratitude for your tireless efforts and your unwavering commitment to justice. Your work is a true testament to the strength and integrity of our justice system and serves as a source of inspiration to all of us. As we gather here today and celebrate the achievements of the judiciary and recognizing the important role it plays in protecting our rights and ensuring that justice is served. Thank you for your hard work and dedication. May your unwavering commitment to justice and the rule of law continue to inspire us all. Thank you.
Well, thank you, Mr. Douglas, and thank you to the Minister for her words of support.
Much love.
And then I call for Ms. Clark, the Director of Public Prosecutions.
Thank you, my Lord, and good afternoon. I crave your indulgence to gratefully adopt the protocol ably established by the Solicitor General. I remain grateful for the opportunity this occasion gives me to highlight to this honorable court and those listening the affairs and the workings of the Department of Public Prosecutions during the past year and our expectations for the upcoming year. For me, my submissions today are a little different. This is my first such speech, having been appointed during the height of the pandemic. If I may, I would like to briefly lay out my vision for our department. My strategic focus is four-pronged. First, to deliver high-quality prosecution services, taking advantage of information technology to achieve effective and efficient outcomes. The second prong is to be responsive to victims and witnesses in the prosecution process. The third, to influence and implement policy, procedure, and law reform. And finally, to deliver legal services within a framework that supports strong governance, professional capability, and staff well-being. My Lord, my department is a cohesive, motivated, professional, and results-oriented team. Every staff member from the lowest to the highest has taken ownership of and is committed to the vision and the mission of the department. All staff have been provided with opportunities for holistic professional and personal development, which has also included their mental well-being. May I mention a major development, my Lord, in the department last year, continuing on the work of my immediate predecessor. In order to discharge our prosecutorial mandate more efficiently and effectively, the department was restructured and will be effective at the beginning of the next financial year. The restructuring has now created 3 deputy director posts, 3 senior crown counsel, and there are 4 crown counsel and 4 crown counsel junior grade. The benefit of the new structure is that it not only increases the number of very senior prosecutors, but it also creates the availability of succession planning to those junior counsel who wish to ascend the ranks. And to that, I thank Mr. Justice Weston. In relation to our work, my Lord, it comes as no surprise that the focus of our trial work for the last year was to make a dent in the backlog of cases, not all of which can be attributed to the pandemic. With the appointment of Madam Justice Sue Williams as the supervising judge of the criminal division and her strict, sometimes very strict, case management hearings, as of this morning, not counting the retrial from the Privy Council, there are only 3 2018 indictments, 2 2019 indictments, and 6 2020 indictments to be tried. That is a major accomplishment. And to add to that, there are only 2021 indictments and 17 2022 indictments. We have made huge leaps and bounds forward with the list. Currently, my Lord, there are no indictments pending where a child witness needs to testify. Madam Justice Sue Williams should be congratulated for her work in this regard, even if sometimes it caused the two of us to clash.
Yes.
As to Justice Wolf, my colleagues and the defense bar, we are a dying breed, but we are still getting the job done. Whilst there were definitely some highlights last year, my Lord, there were some disappointments. And one of those highlights was, in fact, the first use of the new special measures to pre-record a child's evidence. However, it would be remiss of me not to mention the challenges that we have all faced. It is no secret that the criminal division of these courts is the ginger-headed stepchild. The criminal justice system as a whole is under attack, and our infrastructure is aging and not aging well. It is all of us, the bench and the bar alike, who suffer as a result. Our people are being killed, and witnesses are too afraid to testify, for fear of being labeled as a snitch and having their picture go viral on social media posts. We have legislation to allow us remote testimony and the ability to play audiovisual police interviews. But the projector in Court 4 is not working, and it's temperamental at best, as is the Wi-Fi connection. Here in Court 1, the 2 screens have this very eerie green glow, but we make do. There is a TV that literally I and a clerk, or I and an usher, have to physically raise and put on a table for the jury to see. And I do mean me. There is no time to stand on ceremony. It has to be done, and someone has to do it. My Lord, our children are being molested, and we have legislation to allow special measures, but we don't have a purpose-built room to pre-record their evidence. And again, we make do. We use Justice Subeir's criminal chambers. Subeir Williams, my apologies. My department provides the iPads. We also make the Zoom meetings. We sort out the recordings. In the Magistrates court, we set up the live links, but again, those courtrooms are not equipped to handle that type of evidence. My Lord, our serious offenders with mental health challenges, Mr. Wolf can talk about those most recently. There is nowhere for them to be kept to receive the treatment that they require. And again, it's the criminal justice system who has to make do. I cannot speak for the bench, my lord, but I know that we at the criminal bar are tired of just making do. And to be clear, I'm not criticizing the registry. I make these pleas to those in Parliament. I'm sorry, Mr. Lister, it was a bad day for Parliament. But I make these pleas to those persons in Parliament who pass these laws and then don't provide the funding for us to use them effectively. These same people will soon be debating how we spent our money last year and how we will spend our money in the upcoming year. But it is those same people passing sly comments from the safety of the House about innocent people being put in prison and complaining about where our judges park their cars. Forgive me, my lord, for briefly changing the tone of these proceedings. But those who seek to criticize the system should know what restricts the system. And in closing, my lord, the Department of Public Prosecutions is excited for what the future brings. Having heard the Solicitor General, we look forward to continuing to make a positive contribution to the community through our role in the justice system. Unless I can be of any further assistance.
Yes.
Those are my submissions.
Yes, thank you, Ms. Clark. I now call upon the President of the Bar Association, Mr. George Jones.
Much obliged, my lord. Thank you. My lord, the Excellency, President having been established. I trust everyone can hear me. After 21 years on the parade square, I have no problem raising my volume, but sadly, after 54 years, I can't raise my height. I'm truly honored to be able to participate today in my capacity as the current president of the Bar Council and on behalf of the broader Bar Association membership. Those who know me will know that I'm not often found in the courts. I am myself not a litigator by qualifications or by training, but as we operate a blended bar in Bermuda, I humbly acknowledge that as a result, I, as well as all those currently called and registered to practice as members of the Bermuda Bar and in good standing, have been granted the privilege and opportunity to stand before these esteemed members of the judiciary and these courts. At this special sitting commemorating the start of the legal year, on behalf of myself, Bar Council, and the Bar Association membership, I pledge that we will continue to support the judiciary and these courts in ensuring that we collectively provide broader Bermuda with access to law. We will continue to work with the Judicial and Legal Services Committee to ensure the caliber and quality of candidates considered and recommended to Her Excellency, for appointment to the judiciary, and their ongoing professionalism, and integrity thereafter. We will continue to refine and uphold the criteria for being called to the Bermuda Bar, and ensuring the reputation and integrity of our members individually and our profession generally is held to the high standards of our professional conduct. We will continue to find and endorse ways for our collective stakeholders to have the access to law that is their right, and seek to eliminate inappropriate behavior by our members that might impinge, compromise, or otherwise avoidably delay that right to access. We are not here to be served, but to serve. We wish for this legal year to be memorable for its achievements, and we look forward to playing our role in the support thereof. Those are my submissions. Thank you.
Yes, thank you, Mr. George. The Senior Magistrate Anderson is away today. Otherwise, she would be making a few remarks on behalf of the Magistrates Court. So instead, we have Magistrate Chin, who's going to say a few words.
Yes. I'd just like to say before, I'm pleased to see Mr. Jones here, because I understand he was a victim of a hit and run
Correct, yes.
last night.
Last night, that is correct.
I'm glad we clarified that.
I can't promise it won't happen again the way out.
I shall read verbatim the Senior Magistrate's report. Firstly, before I begin, I must say that I'm honored to sit in these February assizes, not only as the Senior Magistrate in Carna, but also as the first female to hold this esteemed post. I'm humbled to take on this most noble calling. I would like to thank Her Excellency the Governor and the Judicial and Legal Services Committee for their faith in me. It's not lost on me that they have given me the opportunity of being the first female Senior Magistrate of Bermuda, and I'm deeply appreciative of their steadfast move towards ensuring diversity within the judiciary. I would also like to thank the Honorable Mr. Justice Juan P. Wolf for his mentorship and guidance, and for leaving a clear path of leadership for me to follow. I wish to congratulate Justice Wolf on his appointment as puisne judge of the Supreme Court. Normally one would add, you'll be greatly missed in our courts, but he's still there. He has only moved down a couple of offices and a couple of courtrooms. I'd also like to express my sincere gratitude to the magistrate who are committed to carry out their duties without fear or favor, with dignity and aplomb. The worshipful Tyrone Chin, the worshipful Kmis Tkumbo, the worshipful Craig Attridge, and the newly minted, the worshipful Maria Sofianis, my fellow War Academy Salter Senior Year and a University of Kent alumnus. Carry out their duties with clear understanding of their responsibilities, which see each decision weighed carefully with fulsome consideration of all the key elements that ensure we have a balanced society. As the good book in Matthew chapter 25, verse 40 says, if you've done it to the least of them, you've done it unto me, which means that we should act with mercy, love, justice, and compassion for those who are less fortunate and in need of care and support. The Magistrates Court has operated in this vein, as I'm sure that all seated and present today know there are those amongst us who find themselves in the throngs of drug addiction or crippled by deliberate mental health issues or shackled by the grip of alcohol addiction. For many years, magistrates simply fined and or imprisoned those who pled guilty or who were found guilty of drug and or alcohol-related offenses triggered by mental health. Statistics and recidivism raise evidence that the criminal justice system of enforcing fines and implementation of imprisonment did not work in Bermuda. With the advent of the Criminal Code Amendment Act 2001, the alternative to incarceration legislation, the Magistrates Court has been able to put non-traditional treatment courts in place to help those who commit offenses whilst in the grips of alcohol and or drug addiction or mental health challenges. Through the Drug Treatment Court, by giving the drug addict the opportunity to find rehabilitation through behavior modification, counseling, offering personal and professional guidance and support, and where warranted, incarceration. Through the introduction of the Mental Health Treatment Court, implemented by the former senior magistrate under my stewardship for the last 7 years, the Magistrates Court has contributed to removing the stigma attached to mental illness by providing supporting services including but not limited to counseling, housing, psychiatric supervision, assistance with substance abuse, medication compliance, financial assistance or employment, and various social and economic needs. The Mental Health Treatment Court deals with the offender's challenges, offering them a clear alternative to incarceration, provides an opportunity to deal with offenders in a holistic manner. However, securing dual diagnosis treatment for people with mental health and cannabis use is unreasonably difficult and continues to be a major challenge. Through the Driving Under the Influence Court, also implemented by the former senior magistrate and presided over primarily by me with the assistance of the other magistrates, offenders who have committed the offense of driving on our roads whilst impaired by alcohol or drugs are given the opportunity to receive counseling and coping skills that allow them to understand the connection between alcohol and drug misuse and their offense. The statistics and the anecdotal evidence clearly shows that the above-mentioned treatment courts are making a hugely positive impact in our community. It is gratifying to hear the stories of those who journeyed through the treatment courts and are now living their lives alcohol and drug-free and with the tools to address their mental health challenges. Most importantly, they have been able to break the chain of incarceration. Furthermore, the statistics show that levels of incarceration have decreased. This can be partly attributed to the efforts of the Magistrates Court and its stakeholders in meting out non-custodial sentences where deemed appropriate. I'd therefore like to thank the following for their continuous assistance and fortitudes. The Department of Court Service, in particular Acting Director Mr. Derek Flood, the supervised case managers and coordinators of the treatment court teams, the Permanent Secretary of the Minister of Justice and Legal Affairs, Mrs. Gina Hurst-Mabry, the Court Liaison Officer of MWI, Ms. Geraldine Smith, Mr. Roger Parrish, Coordinator of the Special Development Program of the Department of Parks, Director of Legal Aid Department, Mrs. Susan Moore-Williams, Director of Child and Family Service, Mr. Alfred Mabry, Magistrates Court Clerks, the Department of Corrections, the Bermuda Police Service, Department of Public Prosecutions, the treatment providers, specifically Mr. Leslie Grant of Focus, Ms. Carla Trott of Turning Point, Ms. Sandy Butterfield, Harbor Light, Men's Treatment Center, Women's Treatment Center, and the Right Living House teams, and all our community partners. It would be remiss of me not to mention our traditional courts. As the saying goes, justice must not only be done, it must be seen to be done. The Magistrates Court handles the vast majority of cases in Bermuda. The Magistrates Civil Court, the venue where civil disputes are heard. As senior magistrate, I will ensure that lawyers and litigants in person respect the court diary. I'll ensure that matters are heard in a timely fashion. Where possible, parties in civil actions will be encouraged to resolve their disputes without need for long, contentious, and potentially expensive trials. To ensure that the civil court will continue to balance the interests of the parties and, where possible, assist those who are overwhelmed with crippling debt to satisfy their financial responsibilities in a management dignified way over a reasonable period of time. The Magistrates' Family Courts. I say that plural, 2 courts. The Magistrates' Family Courts. The family is the bedrock of any society. It is imperative that decisions made on behalf of our children and families are fair and equitable, especially when the aforementioned children and families are in a most vulnerable state. I will ensure that the lay magistrates appointed to the family courts have a balanced view of motherhood and fatherhood and our country in general. At present, lay magistrates are paid a paltry $50 per day, which amounts to $6.25 per hour. This is not acceptable given the complex and delicate nature of the matters which they preside over. I therefore renew a request to increase their daily stipend to an amount which is commensurate with their important duties. I consider suggesting that it be increased to at least $150 per day, which be in line with the suggested minimum wage. The Magistrates' Criminal Court. All criminal matters begin in the Magistrates' Court. The administration of the criminal courts is critical to the rule of law. Due to the COVID-19 restrictions and for health and safety reasons, for a period of time, the Magistrates' Courts conducted matters remotely, even during the lockdown periods. We did so because we are acutely aware that justice delayed is justice denied. Lawyers were appearing in matters online whilst they sat in the home offices, something that was unprecedented. When we were able to return to court, we could only do so with limitation and restrictions. The entire Magistrates' Court had to morph and adapt to the COVID-19 environment. However, we never really totally ceased hearing matters. As a result, we, the Magistrates' Court, never amassed a backlog of cases. To date, we remain up to date and current with our caseload. However, I am compelled to mention that we have observed a deterioration in the standards of those who appear in the court. The next sentence, the senior magistrate has underlined. The Magistrates' Court will take a no-nonsense approach to lawyers and parties who miss court appearances and/or trials, which are adjourned without prior notification and or communication with the court. The failure of counsel to adequately inform the court of their absences puts the court diary into disarray. It frustrates complainants and defendants. Unexcused, illegitimate counsel absences cause matters to drone on for long periods of time. The absences lead to huge legal fees. Also, parties, including counsel, must come to court dressed appropriately. The court security and officers have been instructed to ensure that persons appearing in court are dressed appropriately. Most recently, I have seen pajamas, short shorts, undervests, crop tops, flip-flops, and slides and durags in court. There must be a basic level of decorum adhered to in the courts, not only in appearance, but also in how one addresses the court. Therefore, the Magistrates' Court will be vigilant in ensuring that persons who appear in court conduct themselves in a manner which is consistent with proper administration of justice. Going forward into this legal new year, the courts will be proactive in carrying out its legal and moral mandate. To this, I quote the following. It's not possible to be in favor of justice for some people and not being in favor of justice for all people. Martin Luther King Jr. Some of us wait for our politicians, some of us wait for our clergymen, and some of us sit on Facebook and complain. Others of us shake our face in the air as we lament the problems of the country. I firmly believe that to whom much is given, much is required, and that there are still opportunities for us to holistically tackle some of the challenges within our criminal justice system through the alternative to incarceration legislation, namely Juvenile Treatment Court. Juvenile Treatment Court, in brackets, she puts JTC, will be for youth with substance use disorders and or mental health diagnosis who come into contact with the juvenile court. It will have a treatment-oriented approach, emphasizing family engagement, and will address the substance abuse and co-occurring mental health disorders. Domestic Violence Treatment Court. The Domestic Violence Treatment Court, or DVTC, will offer a therapeutic treatment alternative to both offenders and victims. Family Drug and Alcohol Court. The Family Drug and Alcohol Court, in Britain they call it FDAC, will be especially designed to work with parents who struggle with drug and or alcohol misuse and mental health problems. Probation Review Court. In addition to the treatment courts, there are fruitful discussions between the court and the relevant stakeholders to create a court in which probation orders are routinely reviewed so as to encourage compliance by persons who have been placed on probation. Such probation review court, PRC in brackets, he puts, will enable persons to get back on track and assist them in addressing their criminogenic and mental health needs, secure employment and housing, and most importantly, to be productive members to their community and to their families. Each of these initiatives will require an expenditure of additional capital and human resources, but I'll be steadfast in ensuring that they come to fruition. The former senior magistrate left huge shoes to fill, but I'm up for the challenge. I'd like to take this time to thank the members of the Bermuda Bar who advocate on behalf of their clients on a daily basis in the trenches of the Magistrates Court. I also want to thank the Honorable Chief Mr. Justice Narinda Hargan and the Justice of the Supreme Court for their support and felicitations. On behalf of the Magistrates Court, I want to thank the Department of Corrections, the Police Service, and GET security officers for ensuring our safety. Last but definitely not least, I wish to give my earnest appreciation to the underpaid, under-resourced, understaffed, often underappreciated, and frequently verbally abused heroes of the Magistrates Court, the staff. They are the backbone, the strength, and the face of the Magistrates Court. I'll end by quoting American poet Robert Frost. These woods are lovely, dark, and deep, but I have promises to keep, and miles to go before I sleep, and miles to go before I sleep. Thank you, the Watchful Back Sanjay Anderson, Senior Magistrate and Coroner. Thank you.
Well, thank you, Mr. Chin, for reading that. I start my remarks by acknowledging that the day-to-day administration of justice depends on the collaboration and assistance of a number of agencies. In that regard, I want to thank and pay my gratitude to the Bermuda Bar Council, the Bermuda Police Service, the Department of Court Services, the Department of Corrections, the Office of the Director of Public Prosecution, and of course, the Ministry of Legal Affairs and Constitutional Reform. I also want to acknowledge with thanks the pivotal oversight role performed by Her Excellency the Governor and members of the Judicial and Legal Services Committee in dealing with judicial appointments and judicial complaints. And in relation to that, I note that the committee marks the departure of Crystal Swan, who was the Executive Officer of Government House and in turn fulfilled the role of Secretary to the committee. She is thanked for her flagship service, and equally I want to thank Audley Coelho, who's filling in as an interim support until a substantive replacement is sourced. The International Commission of Jurists, in their work titled International Principles on the Independence and Accountability, and I emphasize the word accountability, independence and accountability of judges, lawyers, and prosecutors. This is a project which is supported by the UK Foreign Office and Foreign and Commonwealth Office. The authors note, and I quote, "The judicial system in a country is central to the protection of human rights and freedoms. Courts play a major role in ensuring that the victims of potential human rights violations obtain effective remedies and protection, that perpetrators of human rights violations are brought to justice, and that anyone suspected of criminal offenses receives a fair trial according to international standards. The judicial system is an essential check and balance on the other branches of the government, ensuring that the laws of legislative and the acts of the executives comply with international human rights and the rule of law. The existence of independent and impartial tribunals is at the heart of the judicial system that guarantees human rights in full conformity with international human rights law. The Constitution, laws, and policies of the country must ensure that the justice system is truly independent from other branches of the state." That's the end of that quotation. The independence of judicial branch and individual judges necessarily implies that the judiciary itself is generally insulated from any examination from its strengths and weaknesses by an outside body. It is therefore important, both as a matter of principle and for retaining public confidence, that the judiciary gives an account of its performance in discharging its duties to the general public. This special sitting and the publication of the 2020 annual report is intended to be a step towards that accountability by the judiciary to the public at large. Accountability of the judiciary has a number of meaning and aspects, but for this special sitting, I want to concentrate on the efficient administration of justice. One starting point for measuring efficiency of the judicial process is to look back to the standards we set for ourselves and achieved prior to the COVID-19 pandemic in March 2021. In relation to criminal cases pending in the Supreme Court, the target standard prior to COVID-19 pandemic, as noted in the report prepared by Justice Bear Williams, was a trial within a 3-month time frame from arraignment. Now, this is a very high standard indeed when compared with other Caribbean Commonwealth jurisdictions and indeed most jurisdictions, and this was achieved in most cases. However, as a result of COVID-19 pandemic during 2020 and 2021 and the shelter-in-place legislation, the majority of the 2018 and 2019 indictments remained outstanding and backlogged until April 2022. As at April 2022, there were a total of 60 backlogged indictments, 11 of which were backlogged prior to the start of the COVID-19 pandemic. And as the Director of Public Prosecution said, and I'm pleased to report that owing to the exceptional efforts of the trial judges in the criminal jurisdiction, out of the 60 backlogged indictments that existed on 1st of April 2022, 33 indictments have been disposed of since that date. The numbers might have changed slightly. As a result, the backlog trial listings for the period spanning 2018 to 2021 have decreased to 27 indictments from the 60 indictments. This is a reduction of more than 50% of the backlog that existed on 1 April 2022. And we expect this trend to continue in the coming year. In relation to civil cases, the speed with which cases are disposed of by the court is largely dependent upon the steps taken by the parties. However, the Bermuda Guidelines for Judicial Conduct provide that a judge should deliver a reserved judgment as soon as practicable and absent exceptional circumstances, justifying a longer period no later than 6 weeks after the conclusion of the hearing. I'm pleased to report that the judges of the Civil and Commercial Court have, in the main, met this requirement even during the pendency of COVID-19 pandemic. Indeed, during the COVID-19 pandemic, the civil and commercial courts were able to function nearly as normally as before with the use of technology, particularly the Zoom and the WebEx platforms. It's clear that the advent of COVID-19 pandemic has accelerated the use of technology in the courts around the world. The acceptance of technology and the acceptance of remote hearings, even in witness trials, particularly in civil and commercial cases, has, I believe, changed the landscape for good. It is vital that we learn from our experiences and explore how remote hearings can be improved, as the use of technology is, I believe, here to stay. Remote hearings in the run-of-the-mill procedural hearings lead to efficient use of limited resources in terms of availability of courts to accommodate other in-person hearings. The use of technology in courts also leads to efficiencies in terms of cost and speed. We have sought to procure a case management system, a system which is intended to be utilized by the Magistrates courts, the Supreme Court, and the Court of Appeal, and is designed to eliminate reliance on paper files moving between 3 different court locations. It will also eliminate unnecessary time spent on corresponding with both attorneys and litigants in persons in relation to documents incorrectly filed with the court. The case management system also allows parties, particularly in commercial cases, to file paper pleadings and pay court fees electronically. As you know, the Magistrates Court convictions often involve a penalty. The case management system records the penalties of fines, accepts payments, and tracks the outstanding balance. The case management system can also manage child support obligations and payments for matters in both the Magistrates Family Court and the Supreme Court. The use of technology in our courts, especially in the commercial court, is of particular relevance in this jurisdiction's efforts to expand and or retain its share of international business. International business, as the private practitioners know, is highly competitive and driven by well-recognized competitive factors. The decision in relation to the choice of a particular jurisdiction is made by sophisticated consumers, largely made of corporate lawyers. To them, one of the significant competitive factors is the credibility and efficiency of the judicial system of the jurisdiction. The efficiency and use of technology is particularly important in the context of the decision makers, as the decision makers are based in established business centers around the globe. It is noteworthy that other comparable jurisdictions engaged in international business appreciate this fact and have embraced the use of modern technology in their judicial systems. As noted by the registrar in her report, I'm pleased to note that the Honourable Minister of Finance has confirmed his support to providing funding for the case management system, and we have commenced to take the necessary steps to complete the procurement process. In my address at the special sitting in February 2021, I suggested that it was vital to the commercial court that we continue to listen and consider the changing needs of the business community. Other commercial courts in other jurisdictions, such as the United Kingdom and the Cayman Islands, have set a formal consultative structure to achieve those goals. At that time, I suggested that the most effective means of ensuring that the commercial court is aware of and catering to the needs of those who use it is the establishment of the Commercial Court Users Committee. The establishment of such a committee was interrupted by the constraints imposed by COVID-19 pandemic, and we intend to implement this initiative in the coming year. In terms of obstacle to efficiency, as noted by Justice Bear Williams in her report and Registrar Wheatley, the lack of designated courtroom facilities for the Court of Appeal, the Supreme Court Matrimonial Family Division, and the Criminal Division continues to present significant trial scheduling issues. This has caused disruptions of the listing of the Supreme Court criminal jury trials, as well as the space being allocated for the hearing of the matrimonial family matters having to be listed based on free courtrooms in the DLBE. Furthermore, the increase in the application in the Supreme Court Civil and Commercial Division has highlighted the need for more court space. As the Registrar's report confirms, collaboration between the courts and the Ministry of Public Works continues with the design phase for the renovations to be completed in the DLBE. Completion of these renovations will see the Court of Appeal, all the Supreme Courts, save for the civil and commercial courts, which will remain in the Government Administration Building, and the Magistrates Courts and services all in one location. With these renovations, we will have a dedicated Court of Appeal, which will be used for other Supreme Court and Magistrate Court matters during the period that the Court of Appeal is not sitting. As the Registrar further confirms in her report, an entire floor of the DLB is going to be designated as the Unified Family Court, which was a recommendation of a committee chaired by the family judge some 10-15 years ago. This will see all Supreme Court and Magistrates Court matrimonial and family matters being heard in this space. I'd like to turn to another topic and would like to say a few words on the issue of independence of the judiciary and financial autonomy. Both the former Chief Justice Caveley and I have commented upon the need for statutory and/or constitutional amendments in order to enhance the concept of independence of the judiciary. Judicial independence is an evolving concept and has a number of different precepts. One such principle is that the financial autonomy and the need to have sufficient resources in order to properly discharge its constitutional responsibilities. The International Commission of Jurists state, and I quote, "The judiciary needs adequate resources to discharge its functions appropriately. As one of the three branches of power, the judiciary receives its resources from the national budget, which in turn is usually determined by either the legislature or the executive. It is essential that those outlining and approving the state budget take the needs of the judiciary into consideration. Inadequate resources may render the judiciary vulnerable to corruption, which would result in weakening of the independence and impartiality. In determining the resources allocated to the judiciary, consultation must be held with the judges or groups of judges, end quotation. The authors go on to refer to various international instruments which recognize the need for the judiciary to receive sufficient funds. For example, the UN Basic Principles establish that it is the duty of each member state to provide adequate resources to enable the judiciary to properly perform its functions. The European Charter on Statute for Judges stipulates that the state has the duty of ensuring that judges have the means necessary to accomplish their tasks properly, in particular to deal with cases within a reasonable period. The Beijing Principles also acknowledge this requirement by stating that it is essential that judges be provided with the resources necessary to enable them to perform their functions. The Latimer House guidelines, which were approved by the judges from the Commonwealth countries, contain a detailed provision of funding, and they state sufficient and sustainable funding should be provided to enable the judiciary to perform its functions to the highest standards. Such funds, once voted for the judiciary by the legislature, should be protected from alienation or misuse. The allocation or withholding of funding should not be used as a means of exercising improper control over the judiciary. It is encouraging to note that jurisdictions similar to Bermuda, in terms of size and constitutional status on the international plane, have made constitutional amendments to achieve this goal. For example, Section 107 of the current version of the Cayman Constitution of recent vintage provides that the legislature and the cabinet shall uphold the rule of law and judicial independence and shall ensure that adequate funds are provided to support the judicial administration in the Cayman Islands. Provisions such as Section 107 of the Cayman Constitution reflect and ensure a longer-term commitment of the community to the independence of the judiciary. It is to be hoped that similar amendments can be made to the Bermuda Constitution Order 1968 within the reasonable future. I conclude my remarks by thanking the registrar, the assistant registrar, the judicial officers, the managers, and all staff of the Court of Appeal, the Supreme Court, and the magistracy for their dedicated service during the last year under, at times, stressful conditions. I'm grateful to Assistant Justice Southey, KC, and Assistant Justice Ford, KC, both based in London, who have assisted the Bermuda judiciary in relation to cases where our local jurists were unable to act. I also want to thank the panel of local assistant justices who voluntarily sit as assistant justices of the Commercial Court for nominal consideration. I invite you to read the 2022 annual report, which will be on the website soon, where you will find the main highlights of the last year and short commentaries on various courts and their respective jurisdiction. It is an important document from the point of view of judicial accountability. And finally, I would like to thank everyone who attended here and conclude by formally declaring the 2023 legal year to be open. And thank you very much for coming. Members of the bar, you can go to the steps.